Welcome to Leyes Cotidianas, or Everyday Law, where we discuss the laws that affect you every day. Today we will be discussing personal injury claims. You may not realize the different areas in which personal injuries could arise. They may arise on property, hotels, apartment complexes, as well as on the road with other cars, or in particular with a tractor trailer. We'll be discussing all of those different arenas in which personal injury claims may arise. Please join us, and thank you. Welcome to Leyes Cotidianas, our Everyday Law, where we discuss the laws that affect you every day. Today we'll be discussing personal injury claims, and we have with us two guests. Our first guest is Jeff Mekelvik. Jeff is a partner with the firm Mekelvik and Lofton, and he practices in the area of personal injury and primarily represents individuals who have been injured. Thanks for joining us, Jeff.
Thank you.
We also have with us Barbara Marshak. Barbara is a partner at the law firm Drew, Eckel & Farnham, and her practice is devoted primarily to defending folks who have been unfortunately sued in a personal injury claim. Thank you for joining us as well.
Thanks for having me.
All right. Many people think of personal injury claims, and I think the immediate circumstance which comes to mind is the car wreck. But obviously personal injury claims can arise in lots of other places. Why don't we talk about, if you can just give us a little bit of an understanding of what the law is as to personal injury claims that might occur on an apartment complex or at a store or at a hotel, any time that there's a property involved and someone gets hurt.
Sure. Well, the law is going to differ from state to state. It's not uniform throughout the country, but the general rule in Georgia and the general rule in the United States is that property owners, business owners have a responsibility to provide a safe environment for the customers, the people they invite onto their stores or onto their properties. They're known as invitees under the law. And if you, as a business owner or a property owner, fail to provide a reasonably safe environment for your invitees, then you're going to be held responsible for any injuries that they might incur while they're on your property.
What would be reasonable? Does it matter on each location? Does it matter what the circumstances of the particular property, what they're doing? I mean, how do we know what's reasonable in any particular environment? Well,
again, the states aren't uniform on that as well, and what is reasonable is really going to depend on the individual circumstances of the case. It's going to depend on the nature of the injury. It's going to depend on the nature of the business and other things as well. The only uniform rule is that they have to provide a reasonably safe environment. But let me give you a couple of examples. For example, in an apartment complex, most apartment complexes are going to have more than one level, which means they're going to have handrails, they're going to have stairs or stair rails, and apartment owner or manager of that complex is going to be required to make sure the stair rail and the handrails are in good condition, they're in a state of good repair, and that they are fit for their intended purpose, and that is to help people go up and down the stairs and have something for people to grab onto. Apartment complexes are going to be required to make sure that their common areas, their walkways, places like that, their stair rails are also in a state of good repair, that they're free of standing water or liquid spills of any kind, that they're free of debris, that they're in proper condition, they're not uneven, they don't have potholes, things like that. And if they don't maintain their property in good repair, if an apartment owner is not there, they're not inspecting their property, they're not maintaining their property, then they're going to be held liable if their tenants or their guests of their tenants are injured.
Okay. You
can also look, for example, at a grocery store, and a grocery store knows that their customers are coming to the grocery stores to look for items to buy, and they know, and grocery stores intentionally do this, they display their items at eye level or above eye level, and they want their customers to be looking at the products that they can buy.
They're looking to distract the customer. I mean, that's the whole point of bringing them in. Okay.
Exactly. And they also know that customers are going to be pushing a grocery cart that's hopefully full of groceries, which means they're not going to be able to see directly in front of them where they're going, and that's why it's so important that grocery stores are regularly inspecting their stores for liquid spills or for food spills. They know those are going to happen. They know they are inevitable because they have so many products, liquid products in their store, so many food products, they know that they will be spilled, and so they have to, a responsible grocery store is going to be constantly inspecting their property for liquid spills to make sure that their customers are safe. And if they fail to do that, then again, they can be held responsible for the injuries that one of their customers might have if they slip and fall and hurt themselves.
Barbara, let me ask you, you typically represent folks that would be these property owners and to make sure that they're doing these various procedures and so forth. What are the common defenses that come up? I mean, just because somebody goes to a grocery store and falls, it doesn't necessarily mean it's the property owner's fault. So what are the kinds of things that a property owner would do to make sure that they're adhering to the law, even if someone ultimately does get injured?
Well, I think that you've hit the nail on the head, which is just because somebody gets injured on a property does not necessarily mean that the property owner did anything wrong or could be held liable as a matter of law for civil damages in a court. And there's a couple of things that we look at, Jeff and I together, when we are evaluating cases, him for the injured person, me for the premises. We look at a couple of things, and I think the first thing that we look at is the status of the person. Is the person, as Jeff said, an invitee? That's the first step, I think, in evaluating these types of claims.
An invitee as opposed to a trespasser?
Or a licensee.
Okay.
Sure. A trespasser obviously is somebody who should not be on the property. You've seen the signs, the no trespassing signs. You're not supposed to be there. You cross the line, you enter at your own risk.
Okay.
There's also somebody who's called a licensee, and they have the right to be there. They have the right to be on the property. They're not trespassing on the property, but there's really no duty owed to that person because there's no benefit that that person is providing to the property owner. The test for determining somebody's status is in Georgia, it's a mutual benefit test. Do the parties benefit each other? The example, obviously, in an apartment complex, the tenant benefits the apartment owner because the tenant is paying rent, and vice versa. The owner is benefiting the tenant because they're providing a place to live. But a house guest.
I was just going to say, what's a house guest?
Right,
Okay.
a house guest is typically considered to be a licensee.
Okay.
And so the duty owed to a licensee is much less than the duty owed to an invitee. And
Okay.
so that's the first thing that we look at. And I think that, you know, as a defense lawyer, I would probably define the standard of care a little bit differently than Jeff would, and this is why we do what we do.
Right.
But from the property owner standpoint, it really is whether or not we exercised ordinary care, and what constitutes ordinary care in the maintenance of the premises.
Okay.
And those are the types of things that we think about first.
For example, let's just use the grocery store example since we've started on that. With the grocery store example, it sounds like ordinary care and reasonable care, in essence, sort of using the same terms or different terms for the same thing, is are we following our procedures? Because there may be a spill, someone may fall. But if the property owner is exercising regular procedures and going by and checking, then that might be an issue. If they have procedures and they're not following the procedures, then that's where we start to run into problems for the property owner in that circumstance. Would that be fair?
Absolutely, and it's important to point out that, you know, the business owners and property owners are not, and the law is well settled on this, the insurer of an invitee's safety. They do not have to guarantee just because someone is hurt on their property doesn't mean that they're always going to be held responsible. But what is reasonable and what is reasonable care and ordinary care, I think is from our perspective is just a common sense standpoint. What is reasonable? As a grocery store, and most grocery stores will tell you that they are constantly inspecting for liquid spills on the floor or food spills on the floor, that they are constantly having their employees going through there. That is their policy. And that's true of pretty much every major grocery chain anywhere, is that their employees, every time they walk through the store, have to look down. They have to look at where their customers are going to be walking. So, you know, that may sound, depending upon your definition of reasonable or ordinary, that may sound more than reasonable or ordinary care, but that is, generally speaking, the standard because you're a grocery store.
In your circumstance.
Again, right. It depends on the circumstances as to what's going to be considered reasonable or ordinary.
That brings me, I think, to the next question. I have, and many folks have heard about circumstances where, let's talk about a hotel, for example. Guests come to a hotel and the hotel may be in an area that has some crime and so forth, and ultimately the hotel guest pays, and I would assume that potentially falls into the invitee definition. In the process of getting the things out of their car, they end up going to the hotel and there's, you know, a robbery, or they get held up, or whatever the issue is, or unfortunately something very serious may have happened. They may have been injured or killed, unfortunately. Mm-hmm. It seems to me that there's a little bit of a difference there. How would the property owner know that a criminal or someone with an intent to conduct a criminal act was going to be on their property, and why would the property owner be responsible for something like that from a criminal nature? Jeff, let me start with you, and then Barbara, I definitely want to hear from the defense side how you all would handle that as well.
Well, that's a great question, and it's one thing that I think a lot of people in this country don't know. They have a right to pursue a claim in that setting. They think, well, I was attacked by a criminal. I can't really blame anybody other than the criminals, and that's just simply not the case. And it's the same standard. A hotel, as a property owner, as a business owner, has the responsibility to provide a safe environment for their guests, and that would include making the environment safe from criminal attack. And you asked, how would they know? Well, a good property owner, a good hotel owner, is going to know the condition or the state of crime that's occurring on their property. And they're in a much better position to know than the guest, who is frequently coming in from out of town and doesn't know the area, doesn't know where they're staying, and doesn't know if they're in a good area or a bad area. They're relying on that hotel to make sure that it's a safe area. And especially if you're coming in from out of town and you're getting a hotel from a name brand hotel, you think, okay, well, you know, they wouldn't put a hotel in a bad place, or I'm going to be safe. And a lot of guests think that and assume that they're going to be looking out for them. Property owners a responsible hotel owner is going to be looking at the crime that's occurring on the property. They're going to know when police come onto their property to investigate crime. Their employees are going to know when crime occurs because their guests are probably reporting it to them. And a truly responsible hotel owner is going to be pulling a crime grid, which you can do. These are a matter of public record. You can actually, as a hotel owner or as a public citizen, you can pull a crime grid. What's known as a crime grid, you give the police or the government a specific address and tell them that you want to know about all the crimes that have occurred at that particular address over a period of time. And you can get a list, and it'll tell you how many armed robberies have occurred on that property. It'll tell you how many murders have occurred on that property. It will tell you how many assaults have occurred on that property. And hotel owners should be looking at that, and responsible ones are. Because you need to know how much security. You can't know how much security you need at a hotel until you know how much a crime is occurring there. And some hotels may not need security guards, or they may not need off-duty police officers, or they may not need really outstanding lighting in their parking areas so that their guests or their employees will know and can see criminals lurking about. It just depends on the property, but you know, all of these things are an example of what a responsible property owner or responsible hotel owner is going to be doing.
Let's do this, Barbara. We're ready to take a break, but when we come back, I definitely want to hear what is it that the property owners would do in these kinds of circumstances, and what are your defenses to this criminal activity. Thank you.
Desde el momento en que ellos llegan a nuestras vidas, dan su primer paso, aprenden a andar en bicicleta. Hasta la preparación de su primer día del 5º grado es un reto para todos los padres criar un hijo saludable. Permítanos guiarle a través de un embarazo seguro y feliz. Aprenda sobre salud, nutrición e información educativa relacionada con el desarrollo de su hijo. Padres e Hijos Atlanta, una publicación del mundo hispánico. Recoja su copia gratis hoy. ¿Cuál es su tesoro más preciado?
Welcome back to Leyes Cotidianas. Before the break, we were discussing personal injury claims, and we were specifically talking about personal injury claims that may occur on a particular property. The last we left off, we were talking about personal injury claims that may occur, for example, at a hotel, and how it is that a hotel owner might be responsible if there had been criminal activity on the property. And Barbara, before we left, we didn't get a chance to chat with you. Tell us, from the property owner's perspective, how it is that a property owner would handle a scenario where a criminal comes onto a property and the property owner has to defend against that crime, and why would that property owner necessarily be responsible for that?
Sure, and I think that one of the first cases that Jeff and I actually had together was an apartment case where something tragic happened at the apartment complex. And unfortunately, living in today's society, especially in a city as big as ours, No place is immune from criminal activity. You can go out to the most affluent parts of town and there's going to be criminal activity. And so I think that just where the apartment complex or hotel or property is located, that's just one piece of the puzzle. Obviously, in more high crime areas, then there is going to be a little bit heightened duty of care for that property owner. I think that the thing that property owners struggle with is what constitutes a reasonable response knowing that you have criminal activity. And that really, a lot of times, frankly, is a jury issue as far as what steps did the property owner take. In the cases that I've handled, the first thing that we do, obviously, as Jeff mentioned, is we look to see what criminal activity is present around. And that's important because if, for example, we're talking about a woman who was raped at a hotel, all right, and there's criminal activity around that hotel, does that mean that the hotel had some obligation to take steps to prevent the rape? Well, in what I do, the answer is never black and white. It's always maybe. And one of the things that we have to look at is, what was the other criminal activity that was around the area? Now, somebody like Jeff, who's pursuing a claim, is going to say, well, any type of criminal activity should put the property owner on a heightened notice. Okay. Exactly. Somebody who's defending the property owner, you want to put yourselves in the steps and in the shoes of the property owner, and you want to say, well, were there muggings? Are we talking about physical criminal activity where there were actual muggings, where there was somebody touching another person, or was it really property damage? Are we talking about car thefts or vandalism? Mm-hmm. And of course, my argument would be for the property owner, if what we're talking about is some random car break-ins, there really is no heightened duty to protect customers from something as invasive, frankly, and as horrible and as tragic as a rape or a shooting or one of those really, really malicious types of criminal activities.
So it really sounds like it very much depends on what the history is and so forth. And if there'd been a history, that's one thing. But if there hadn't been a history and it was potentially a random occurrence, then it starts to understand, well, how do we look at just sort of the general knowledge that's out there and the general history?
That's right. And you also want to look at the steps that are taken. I think that what criminal history is around the area is certainly an important component of the case. But I think that the second component of the case is what steps were taken. A lot of times in premises cases, and Jeff and I have gone down this road a couple of times, but in premises cases you look to see, were there lights that were installed? Was there some type of maintenance program in place so that you've got somebody who's actually walking the property and making sure that the lights are functioning? Mm-hmm. I mean, it's one thing to have lights, but you've got to make sure that they're actually turned on when they're supposed to be on. Mm-hmm. Was there a fence in place? Was there an electronic gate? Was that electronic gate functioning? Was there a security guard? A lot of apartment complexes and hotels don't actually have security guards roaming the premises. And then the question becomes, given the criminal history as it existed, would that have been an appropriate step? So it's really a multifaceted, frankly, examination.
It sounds like it's not always clear, and as you mentioned, really, a lot of times this is going to be for a jury to listen to all of those facts in that particular case, to hear all of the evidence, and then make the decision, is it reasonable for this property owner in this circumstance, and so forth. All right, let's change our focus a little bit now away from necessarily premises claims where personal injury might arise, and let's focus now on what we commonly think of as personal injuries that may occur on the road. And I think most folks are fairly familiar with just the standard auto collision that might come up, and sort of they understand the process. People exchange insurance cards, and you sort of go from there. If it's much worse, obviously the lawyers become involved and so forth. Let's talk about a particular kind of collision, though, that folks may not, and hopefully will never have to experience or know someone that experiences. Let's talk about if there's a collision with a tractor trailer. Jeff, let me turn it to you now. With tractor trailers, are there particular rules or laws that are in place with tractor trailers that make those kinds of collisions different than a typical collision that, unfortunately, let's say you or I might have if we were on the road?
It's a very different claim, actually, than automobile on automobile collisions for many reasons. First of all, there are many automobile on automobile collisions that happen where people like you say, exchange insurance information, wait for the police, and go about their business. They walk away without a scratch or not with any serious injuries. You can take that same automobile collision and put a tractor trailer as one of the vehicles, and in the same set of circumstances, the person could either be killed or seriously injured, unfortunately, because of the big difference between, the obvious big difference between tractor trailers and automobiles.
Just the size,
absolutely,
and the weight.
Absolutely. A tractor trailer has a gross vehicle weight rating of 80,000 pounds.
Mm-hmm.
The average car weighs only a few thousand pounds, and that weight difference means that when there's an accident between a tractor trailer and an automobile, the tractor trailer always wins. I mean, Barbara will tell you, we almost never see a tractor trailer driver injured in these types of cases. It's even when the other driver driving the automobile has been seriously injured or killed, the tractor trailer driver usually walks away without a scratch. It's also different because, like you say, it's a heavily regulated industry, and it's heavily regulated by the federal government and by pretty much every state in the country. And it's because of the danger that tractor trailers impose on the roadways, because of their weight differences. We don't want anybody, just anybody, driving tractor trailers, and that's what these regulations are designed to ensure. And people that hire tractor trailer drivers, companies that hire them to haul freight, they're known as motor carriers. When motor carriers hire drivers, they have to look at that driver's employment history. They have to make sure that they were good drivers where they were, that they didn't have any, like a bad safety record. They have to look at their driving history report from the government. They can get a DMV, a Department of Motor Vehicles, check on any individual driver to confirm that they didn't have a bunch of collisions or tickets, and that they weren't unsafe drivers. And when they hire these drivers, they have to make sure that they're continuing to be good drivers. They have to randomly drug test them for drugs or alcohol to make sure they're not obviously operating a tractor trailer under the influence of drugs or alcohol, and they have to make sure that they're not driving too many hours in a day or too many hours in a week, because the government regulates that as well. It tells motor carriers how often how many hours in a day a driver can drive, or how many hours in a week a driver can drive. So it's regulated with the idea of, we don't want just anybody driving tractor trailers on the road, because it's so dangerous and it's such an awesome responsibility.
No, Barbara, let me ask you. Let's say, for example, unfortunately, there has been a collision with a tractor trailer. Let's say there's also, just assume that there's been some kind of a violation of maybe the number of hours that were driven and so forth. As the counsel for the defense, obviously you're concerned about what happened to the victim, but you still have to evaluate it. What are the kinds of things that you look at and you consider when you're evaluating that claim? How do you decide how it is that this matter could potentially be resolved, or what do you look at?
Well, I think that in evaluating any claim, the first thing that you want to look at is whether or not there's any liability for that claim. So that's the first thing that you look at. And in trucking cases in particular, I mean, you kind of set me up for failure, Charlotte.
No, not on purpose.
You said that there was a violation of the federal reg, and that puts me obviously at a disadvantage. In most cases, that's the first thing that I look at, is I pull the driver's logs, I pull the driver's history, I pull the file on the vehicle, because a lot of times these vehicles become disabled in the roadway. And that's one of the issues in those types of cases is, was the vehicle maintained appropriately? Was it inspected appropriately? If it became disabled in the roadway, did the driver act appropriately? Did the driver get out and set the warnings that he was supposed to set to prevent any type of collision? And so those are the first things that I would look at, is whether or not the driver did anything wrong. I think, unfortunately, as Jeff said, any time that there's a tractor trailer versus a private automobile, the tractor trailer is going to win. That doesn't necessarily mean that it's the tractor trailer's fault. Anybody who has driven on I-285 in Atlanta has seen people do really, really stupid things in front of tractor trailers. And so that's one of the things that we look at is this truly the fault of the tractor trailer driver? Was this something that could have been avoided? The second component, once you evaluated, well, this is probably something that we're going to need to talk about, you then evaluate the damages. And that is a tricky thing to do, frankly. There are different components of damages in civil cases. Obviously, the one that most people know about are special damages. Those are the medical expenses. the lost wages. There's something that you can quantify. You can put an actual number on those damages. The trickier part of evaluating these types of cases are the general damages, which are sort of the intangible damages. And that's where you really have to have an experienced lawyer who knows how to evaluate cases, frankly, because we're using our experience in guessing what a jury would do with the same set of facts and circumstances. And you look at all kinds of things. You look at the person who was injured. How has the injury affected them? How has it affected their family life? How are they going to, frankly, how are they going to appear in front of a jury? And it's really, there's no exact science to it. It's really just based upon experience and a lot of different things swirling around.
If you were speaking with someone that obviously had hopefully never been involved in this, but they have a family member or something has come up and they have now experienced some kind of a personal injury, what would in essence be sort of the first thing that either one of you would tell them if you just ran into them? What should they do if this is an issue?
Well, if I just ran into them, I would tell them to go see a lawyer.
Right.
And I would tell them to go see a lawyer immediately. The first question that I always ask anytime a client comes to see me, and I'm sure this is the first question that Barbara always considers too, is when did this happen? Tell me the day this happened. Because there is a time frame in which you are allowed to pursue a claim, to file a lawsuit against someone. And again, the states aren't uniform on this, but in Georgia, the rule is that you, generally speaking, have 2 years from the date of your injury in which to file a lawsuit against someone to pursue a claim. And that, for example, it's May 4th of 2012. If on May 3rd of 2010 I'd been involved in an accident, I would no longer have the right to pursue a claim today against someone that injured me, even if they were negligent and even if I was seriously injured in it.
So there's a time limit, so you've got to be aware of those time limits as well.
And that's the most important question that you can, that's why it's the first question, because it's the most important, because if you're past that time frame, you can't help somebody. And I've had that conversation with people, and it's a hard conversation to have, to tell them, you know, yes, you have a great case if it wasn't for the fact that you waited 2 years. And so that's why I would tell them to go see a lawyer immediately if you think you have a claim and you want to find out if you want to pursue it, because a good lawyer is going to want to look at your claim. They're not going to want to just rush out or run out on the 2-year anniversary and file a lawsuit. They're going to want to talk to witnesses. They're going to want to look at documents. They're going to want to try to figure out if you have a good claim and the people that they need to talk to, who's going to be important in the case. And a lawyer needs time to do all these things,
right.
Obviously.
And they can't do it without it.
So you need to look at that. That's important.
All right. Well, thank you all both for joining us. I think we have a little bit better understanding of where personal injuries may occur and sort of the different laws associated with those different areas. I appreciate it, and thank you both for coming.
Thanks, Charlotte.
Thank you.
And if you'd like more information about this show and many others, please join us on www.leyescotidianas.com. Thank you.
Leyes Cotidianas les llega a ustedes gracias al generoso apoyo financiero de la Fundación de Justicia Civil del Estado de Georgia. Mundo Hispánico, el vocero de la comunidad hispana desde 1979. La estación transmisora WPBA no tiene licencia para practicar leyes en el estado de Georgia. WPBA y los patrocinadores de este programa no son responsables por las opiniones expresadas ni la información proporcionada por los abogados en este programa. Este programa se ofrece como un servicio público. El objetivo de este programa es de informar y educar y no de proveer consejo legal. Si usted necesita consejo legal, favor de consultar a un abogado.